Good evening. So, we are talking about the hijab verdict delivered today by the Karnataka High Court, the full bench of Karnataka High Court. The judgment had been reserved uh, nearly a week ago, and today, of course, the detailed order has come out into the public domain. And to cut this long story short, the Karnataka High Court has upheld the Government of Karnataka order, which effectively prohibited the wearing of hijab for women, girls, Muslim girls, by virtue of an order which had been issued under the Karnataka Education Act, a state act of 1983. So this was argued at length before the full bench, and numerous headlines had also been gathered as to how the girl students were being prohibited from entering the college premises, from attending the classes, because the uniform prescribed by the college or the education institution was such that hijab was not allowed as a part of that. So today, that judgment is out. So we'd discuss briefly. It's a well argued judgment available in the public domain, detailed order. Any person who's interested to delve into deeper details may refer to that. But effectively, what were the grounds in which these was argued? And more importantly, what are going to be the implications of this order, where people may allege, any citizen may allege a kind of a disguised discrimination. So first issue which was framed before Karnataka High Court was that wearing a hijab or a headscarf is a part of the essential religious practice in Islamic faith. So that was what the petitioners were propounding. And therefore, the Article 25, which deals with the right to religious freedom, that it was alleged was being infringed. So as far as this point is concerned, the court has effectively said that there is no Quranic mandate, and it is not an essential practice that women must wear a hijab, and therefore you cannot argue your case on the basis of Article 25. So this ground was rejected. And the other point which was raised on behalf of the petitioners was under Articles 19(1)(a), which is basically freedom of expression. So it was argued that wearing a hijab is that freedom of expression. You're expressing yourself, and therefore you're infringing upon that through a colored or colorable government order. And of course, also Article 21, and as we know, Article 21 deals with life and liberty, but right to privacy is now a part of those fundamental rights. You cannot be stripped of your privacy. No one can get into your privacy. It's a violation of the fundamental rights enshrined under Article 21. So the petitioners had also argued that this is an infringement to privacy. The modesty of a Muslim girl student, women student, demands that I have this privacy, that I may cover my head. So what the full bench of Karnataka High Court has said essentially is that, well, these are reasonable restrictions. They can always be imposed on grounds of public order, morality, etc. And no fundamental right is an absolute right. And therefore, if the government has prescribed this, well, then nothing wrong with it. So this ground of freedom of expression, hijab being enshrined right to express yourself, your choice to wear that, they say, no, you have to submit to the institutional discipline, more so when it is mandated by a government order. And also there is nothing about privacy. So therefore, Article 21, this was also rejected by the Honorable High Court. And interestingly, as I read this article, one of the arguments was that, the Kendriya Vidyalayas, which are run by an autonomous organization under the government of India, the central schools, they do allow a headscarf. And to this, the court said that, it is not mandatory for the state government. Education is a concurrent list subject. And if the government of Karnataka has come out with its own code, and therefore you cannot argue and read into this by saying that, the Kendriya Vidyalayas prescribe this or permit this, they've got their different code. And the court added that, quotes, it hardly needs to be stated that the uniform can exclude any other apparel like a pagwa or a blue shawl that may have visible religious overtones. So that is a passing observation, but essentially what they've said is that it is not mandatory for you to follow the Kendriya Vidyalaya issues and the uniforms prescribed therein. And then is a question of Article 14 and 15, whether the government order dated so and so, apart from being incompetent, is without application of mind and manifestly arbitrary, and therefore violates Article 14 and 15, which is equality before law and non-discrimination. Essentially, what they're trying to argue is that this is only qua Muslim girl students, or when they're saying hijab, essentially they're targeting the Muslim girl students. And of course, what the Karnataka High Court has said that the impugned order could have been more happily worded. They've used the word like integrity of India, unity of India, public order. Of course, this is, those words have a different connotation, and perhaps using that to bring it as a reasonable restriction was an overkill. But they have, essentially said that the order could have been more happily worded. But they quoted actually Oscar Wilde or Oscar Wilde, whatever you have, that there is room for improvement even in the heaven. So essentially, what it means is that the hijab order of government of Karnataka issued under the power to issue directions has been upheld. And for the moment, this is not the end of the story. This would had caught headlines, so on and so forth. And therefore, it may lead to further litigation. I'm told, I have not verified independently, that this was a similar order was also passed by the Karnataka High Court. But now the full bench of, Kerala High Court, and now the full bench of Karnataka High Court has come out with this order. And therefore, we have to look at it very carefully. Of course, the matter is going to land up in the Honorable Supreme Court of India, and it will go on from there. Now, some of my friends I was discussing informally was that, this may have implication for Sikhs and Sikhs boys, where turban may or may not be prescribed as a uniform. I don't think turban universally is allowed, not only in educational institutions, and rather even in the Indian Armed Forces. So I don't think that it would be just spooking the Sikh community. In any case, one has to refer to the explanation in the fundamental rights of Article 15 and really see that the Sikh community has been given certain privileges, I would say, under the Constitution. So that's not a subject of discussion at this stage. But right now they have said that, okay, this is an educational institution. You have to submit yourself to the institutional discipline. And the Karnataka High Court, once it prescribes a particular uniform, everyone has to adhere to it. And that's what that matter is. End of the story. Now, we were having an interesting discussion, and this is where I would like to spend about 5 minutes on before we roll this thing out. the fact of the matter is that all the fundamental rights that you have, and those fundamental rights, including equality on basis of caste, color, creed, place of worship, and so on and so forth, religion, faith, language, place of birth, etc., whatever, those are available to you only against action of the state, instrumentality of the state, state government, its public sector undertakings, statutory bodies, central government, state in a very wide sense it has been. So if the state discriminates, they say, okay, we are not going to, admit students of a particular faith or born somewhere or a particular caste, etc., and so on and so forth, then that is purely hit by the constitution and is patently illegal. Now, the question which was arising is that increasingly there are some building societies in various metropolitan cities which are saying that, okay, fine, we are not going to allow tenants or even ownership to people professing a particular religion. Now, those are totally private bodies. Those are not by any stretch of imagination instrumentality of state. So it is like, you trying to board a bus or a train run by a private company, an aeroplane, and someone stops you and says, I'm not going to give you this service because you don't speak this language or whatever. Now, are this protection that we've argued under 14, Article 15, Article 19, Article 25, Article 21, so is the protection of the fundamental rights available to a citizen when confronted with a private sector organization, beg your pardon? All the protections that we have are vis-a-vis the instrumentalities of the state. So this has opened up a debate, in my opinion, and sooner or later this issue will come up, that tomorrow can a restaurant say that I am not going to allow a Christian student or a Christian person, or only allow people of a particular religious denomination to enter. Otherwise, it's a restaurant which you are willing to pay the money, you're willing to buy that service. Now, insofar as the untouchability is concerned, that was abolished by the Constitution of India, very much a part of the Indian Constitution from day one, but it took about 6 or 7 years for the Social Disabilities, rather the Prevention of Social Disabilities Act, I think 1957, to come up, under which untouchability was made an offense, a punishable offense. So therefore, there are two parts of it. One is there is a public place of worship. And if someone is barred entry, saying, hey, you're untouchable, you belong to a scheduled caste, and so on, it becomes an offense. But more importantly, if you have a private place of worship and you selectively allow some people in, but you say, hey, I'm not going to allow you to enter because you belong to such and such caste and so on, then you still, even if it is your private place, even if it is your private restaurant, a private haircutting salon, you cannot bar people on the grounds of their being untouchable. But the definition of untouchability as contained in that statute, I think my lawyer friends would be able to argue that better and delve deeper into that. That untouchability is restricted to the 4 religions in which untouchability was rampant, or maybe is sparingly rampant and still goes on in some parts of the country: Hinduism, Sikhism, Jaina, and Buddhism. Now, whether you can stretch the definition of untouchability to include this, so it's a hypothetical situation. Can a building society say we are not going to allow Muslims to buy property or transfer, or a tenant to move? So those are questions which are open. Whether they would attract the extended interpretation of the Untouchability Offences Act, the Prevention of Social Disabilities Act, I don't know. But right now, we must be very clear that all our fundamental rights are basically a restriction on the power which the state has to discriminate against you on one ground or the other. So, equal protection of law and equality before law, that's what this is all about. It does not, as such, apart from the limited protection under the Untouchability Offences Act, provide you with any more protection vis-a-vis the private sector players. And now, in a scenario where increasingly the role of private sector is increasing, public institutions are in their operational space becoming narrower and narrower. It remains to be seen as to whether some litigation will eventually flow out of this, where purely private bodies, like say a listed company, can it say while incorporating itself that I am not going to allow a particular community to be shareholders? So that would be a big constitutional issue, in my opinion. But right now, I think for the moment, the narrow and developing news was that the Karnataka High Court has upheld the government order, and the government order prescribed as a part of uniform not wearing the hijab or the headscarf for the girl students, and all the prongs of attack of that order. It was argued at length before the full bench comprising 3 judges, including the Chief Justice, but the detailed order is out. So all the assaults on that order to declare it unconstitutional as being violative of fundamental rights under Article 14, 15, 19, 21, 25, all have been rejected. Of course, already I'm told in breaking news that people have filed special petition in the Supreme Court, and the matter eventually would be heard there. But for the moment, it appears that this order stands, and the other issues which I framed would eventually come up in one form or the other, where a particular religious or linguistic minority may feel discriminated not by an instrumentality of state, but by a private sector organization. So that, friends, was all for now. Have a great evening ahead, and we look forward to the swearing in of the new Punjab Council of Ministers tomorrow. Bye-bye for now.